Appeal Charter Court holder against Robert Stokes, representative of the estate of Walter Edward Stokes, deceased.
Yes, Mr. Mark.
Much obliged, my lord. My lords and my lady, I appear on behalf of the appellant, assisted by Mr. Robert Strang and Ms. Catherine Bailey, and we are instructed by Mrs. B.D.B. Pittmans. My learned friend, Senior Counsel, Mr. Ian Benjamin, appears on behalf of the respondent. He's assisted by Mr. Kervin Garcia, who is appearing virtually, and instructed by Signature Litigation.
So Mr. Garcia is appearing virtually but invisibly to us at any rate.
He has certain extra responsibilities now, public office, so he could not come.
Well, he's virtually welcome as if he was here.
Much obliged, my lord. My lords and my lady, in this appeal, I will be submitting that the judge correctly understood the tasks which were before her, and she made findings which were properly open to her. Those findings were based on her assessment of the witnesses and the evidence adduced before her. The Court of Appeal wrongly reversed the judge's findings of fact. The Court of Appeal felt it was able to do so because it misconceived the issues in the case, and it applied the wrong legal test. The Court of Appeal found that one needed to look no further than the terms of the disputed deed of conveyance and the prior written agreement for sale. The Court of Appeal did not engage with the judge's findings that the written terms of the agreement for sale, which were plainly ambiguous, did not represent the parties' true agreement, and that the parties' true agreement could be discerned from the survey plan that they drew up for the agreed purpose of depicting the land to be sold. In my submissions, I would first take the board to the survey plan to show the land in question and the circumstances relevant to the case, and then to consider the deed and the agreement for sale, the written agreement for sale, before setting out the parties' respective cases on rectification. I then intend to show how the judge approached her task and the findings she made before, if I may say so, expose the errors of the Court of Appeal. Finally, I wish to address briefly my objections to the respondents' raising of a new criticism of the judges based on material that was not pleaded or put in evidence or argued before her. So, if I may, I would first show the board the land concerned, and that is at page 22 of the electronic bundle. It is a plan dated the 23rd of March, 1982, and it was done by the surveyor, Mr. Winston Sylvester. It would be noticed in that plan, it was known as document A2 in the courts below, and it will be noticed that to the west is the Maracas River, to the east is the Maracas Royal Road. The west.
Give me the page number. I'm really sorry. I'm
sorry. Page 22, my lord.
Thank you very much.
To the east is the Maracas Royal Road. To the west was the Maracas River, and the westernmost parcel of land, 534 square meters, is the main parcel of land, referred to as the main parcel of land, sold by Walter Stokes to the respondents. Directly to the east of the main parcel, the land described as formerly Guaira Estate, now Stokes, is what was described as the adjoining parcel in the courts below. That was the land retained by Walter Stokes. To the south of the adjoining parcel marked right-of-way is the access road, the land in dispute. This was used as an access road by the inhabitants of the main parcel and the adjoining parcel. On the adjoining parcel, there were 3 buildings along the access road, immediately to the north of it, occupied by tenants of Walter Stokes.
Can we see those on the plan?
On the adjoining parcel, sorry? Sorry? No, you can't, I'm sorry, my lord, you cannot see the tenant's position on the plan, I'm just mentioning it.
But can you tell us where it is? Or is there any evidence that shows where it is?
The adjoining parcel would be what is marked as formerly Guira Estate, now Stokes.
Well, there are 2 areas which are marked like that, but you mean the one...
It's the one just north of the right-of-way.
Is that in fact one area which is joined by the broken line?
It's
the adjoining land, the formerly Guira Estate, now Stokes.
the adjoining land is south of what was formerly Guira Estate, now Stokes. If you look to the north of what is formerly Guira Estate, now Stokes, north of that was another piece of land, but that is not the adjoining land. That land is also owned by Stokes. But in respect of this case, it concerned the main parcel, which is 534.35 square meters. Yes. And east of that is the adjoining parcel.
Yeah.
And south of that is the right-of-way.
Yes.
So the houses were along the southern boundary, were they, of the retained land?
Yes, yes, my lord.
The adjoining land.
The evidence of the tenant's building is at page 475 at paragraph 4.
475?
Yes, at paragraph 4. and which is not mentioned on the plan. To the south of the access road, the landmark Guira Estate is a land that was subsequently bought in 1992 by attorney Uday Ramachan, who gave evidence in these proceedings. So the part marked Guira Estate, that is south of the right-of-way, that is where Mr. Ramachan bought. And he was one of the witnesses, so I thought I should let the board know.
So you're saying that even though the adjoining land also borders on the road, the tenants need access to the right-of-way to get to the road?
Yes, yes, ma'am. I would next show the board the deed of conveyance, which the respondent sought to rectify, and that is at page 24. And this was a deed made between Walter Stokes as the vendor and the respondent as the purchasers. And it would be seen that the vendor, Walter Stokes, is said to be the owner of the land described in the first part of the schedule, if one looks at the second paragraph of the deed. And these are described as the said lands. The ownership is said to be subject, however, in that same paragraph, to the right of passage over and along the strip of land described in the second part of the schedule, the right-of-way. Yes. The deed recites that the vendor has agreed to sell the said lands, that is the land in the first part, but subject to the right-of-way, and proceeds at clause 1 to convey in return for 180, that's on page 25, the said land subject to the right-of-way. And the schedule is at the bottom of page 25. And it would be noticed that the first part describes the main parcel of 5,434 square meters, and the second part on page 26 describes the access road, 430 square meters. And this is confirmed by the plan attached at page 28.
This, of course, is in black and white, but is the original right-of-way part coloured green? Or was it edged or coloured? I can't remember. It's coloured green.
The plan that is attached to the deed was amended from the original plan.
Yes, but
But it's now colored, it's now been colored
now appears
green.
in
Green.
the trial bundle.
Yes.
Is the right-of-way bit, the second parcel,
Yes.
coloured green?
Yes, yes, my lord.
So just be clear, that's page 22 of the bundle,
Yes, yes, my lord.
and so that is
Oh, I
coloured
thought we
green.
were looking at
It's
28.
at page 28,
Yes.
Ah, right, okay.
and it's the same right-of-way that was at page 22.
Yeah.
And in addition, this has got the drain, is that right? Drainage way?
Yes, yes, my lord.
And this document is dated
Yeah, this is dated the 21st of April, which was attached to the deed. The plan is dated the 21st of April,
and the deed itself is the 18th of August.
August. And that would be important when we come later down, my dear. And the plan, which is at page 28, was
Before we
referred
leave
to
that, sorry, where do we see the 21st of April?
at the bottom. Look at page 28,
Yes, thank you very much.
at the bottom, 21st of April, 1982.
And that existing drain, which is between the river and the right-of-way land, the 430 square metres, that is what was
Not hearing what you said.
added in.
The existing drain was
Yes,
one of the
yes.
things that was added in.
Yes, the existing drain is what was added in there, in which there was a dispute as to when that was done.
Yeah.
But that is the drain that was added in.
But these two documents are both successors, aren't they, of a common ancestor, in the sense that there are things on 22 that don't appear on 28, such as the words right of way, and things on 28 that don't appear on 22, such as the drainage. And the signature, although by the same person, I think is not the same signature as such, is it? Under just above the date. And on 22, you can see March written, but there's no month put in on 28. So it looks as if these two are both, if you like, progeny of a common, but we haven't got it ancestor.
Yeah, it's also just to point out, since we're doing this on page 28, the text at the bottom of the plan has changed as well. So it's become a plan of two parcels, coloured
yes.
pink and green.
Yes.
Page 22 is just parcel of land coloured pink.
Yes.
Can I just check on page 22? Am I right in thinking that the parcel of land coloured pink was just the 5340 parcel? Is that right in the original?
Yes, the parcel colored pink was the parcel marked 5340.35.
Yes, thank you.
And that was a plan of one parcel.
That's consistent.
And it's consistent with the description underneath the drawing. The plan on page 28 shows a plan of two parcels of land. It says plan of two parcels of land, colored pink and green, and it says pink and green respectively, which meant that the plan, the part 5340.3 was colored pink, and the other part, which was the right-of-way, was colored green, but the plan did not have it colored green. And this plan was,
This plan on 28, you say, didn't have green.
no, it did not have green.
I thought you just told us that it did have green.
On 28 did have green, sorry.
Yes.
On 28 did have green.
It's the original in court.
We don't have the original.
We didn't have the original in the court, my lord. I think we had it below,
Do
but
you think we need to know whether it was or wasn't coloured green, Mr.
all three, my lord, okay. Whether we think it was. We'll undertake to supply that information to the court, my lord. This plan, which was at page 28, was known as the document A4 in the courts. So the plan, which is the amended plan on page 28, shows that the access road is surveyed and measured at 430 square meters. And in the plan that was before, page 22, the right-of-way did not have any measurement, and it was described as a right-of-way, but this is just measured 430 square meters. So that's another change. And as we see there, there's a drain depicted, and the written description of the plan is a plan of 2 parcels of land colored pink and green, and the total area of the 2 parcels is given. And we undertake to provide the plan, the original plan, which shows.
Could you please, for my benefit, just identify in a list for me now, briefly as possible, the changes that you say are material between the 2 plans?
Yes. My lord, in the plan at page 22, it was a plan of a parcel of land colored pink, and was a plan of a parcel of land, 1 parcel of land.
Mm-hmm.
And it also showed that in the plan at page 22, the right-of-way is described as a right-of-way with no measurement, no survey done to it, no measurement. And in the plan at page 28, it does not have the right-of-way mentioned, but it is measured as 430 square meters.
And in terms of colour?
Yes, in the color, in the plan at page 28, you have the plan of 2 parcels, 1 colored pink, that is the main parcel, 534.30, measured pink, and the right-of-way colored green. Any other difference? Yeah.
And it's got the size. 430 square metres.
Yes, no, what it is.
And then in terms of dates, one is March and the other is April. Is that
Yes, sorry, and the date. One is the 21st of April, 1982, and the plan, the first plan, 22, is the 23rd of March, 1982.
And is that date at 28? That's Mr. Sylvester said he wrote in that date, did he? It's his handwriting.
Yes, my lady. Mr. Sylvester stated that he did that on the 21st of April. Initially, they were saying it was in August, but he admitted in cross-examination it was the 21st of April.
looking at 28, it does look as if the main parcel, the 5340 parcel, is shaded in some way, but that may just be the photocopying. Or
Yeah.
was it all coloured in pink, or was it just outlined in pink?
I see. Meant to be coloured.
As far as I can recall, and we'll have to look at the plan, but it was all colored in pink. That as
Was
far
that
as,
different from 22?
well, I think in fairness that my recollection is that the plan on page 22, the main parcel was colored in pink, and the plan at page 28, the main parcel was colored in pink.
And I think on 28, the small parcel was coloured green. I mean, one can.
Yeah,
It's hard to pick up from the photocopy, but there's a little bit of dotting on the green, on the small parcel as well, which may indicate coloration.
Yes, and the one on page 22 did not have any color on the right of way.
No.
I'm not sure at all that this matters, but I think it's clear that there are other very small changes between 22 and 28 in terms of some of the sort of markings along the lines and so on. So it rather gives the impression that Mr. Sylvester, in effect, didn't have a standard copy on file, but produced these documents separately on each occasion.
Yes, what Mr. Sylvester said is that he did not make any changes to this plan of on page 28. The only change he made was depicting that drain reserve. He was asked in cross-examination if he made any other changes, and he said he did not make any of these changes.
Well, sorry, but we've already seen that there were some changes. They're quite small.
Yes.
But for instance, removal of the words right of way and putting in the 430 meters. What I was referring to, I mean, I don't want to take up time doing it, but if you look below the 430 meters or right of way, you see the marking 10220-RIV. Yeah. It's in one plan, it's in uppercase, in the other it's lowercase. Yeah. And you can see tiny changes like that actually with some of the other things. So I'm just making the point that it's not as though he had on a computer a standard and then just juggled with that. He seems to have started afresh, obviously with the same measurements that he'd taken before, but then drawn up the plan anew. Is that a fair impression?
It seems as though what happened is that he had these survey plans prepared, and he had a few copies of what was on page 22. And what happened is that when they had to do the drain reserve, he did the drain reserve, but the person who had the plans in the possession at all times was the first respondent. So it was the first respondent who took the plan to Mr. Sylvester for him to do the amendment, and I'll show the board that.
So you're saying that Mr. Sylvester said in evidence that he had not done the colouring in?
Mr. Sylvester's evidence was that the only change he made to the plan was to put the drain reserve.
But there's so many differences. I mean, if you look at the words Maracas River, they're in a different place on the two plans by reference to the northern boundary of the first plot, the first parcel, the main parcel. Well, everything's different. It's just been redone.
Yeah.
Although the actual boundary lines look as if they're very much the same.
I mean, I rather assume that Mr. Sylvester went to the land, took the surveying measurements, so he had them somewhere on file, and on the two occasions when he was asked to produce a plan, he used those measurements and then drew up the plan separately each time, using very small differences of notation for some of the the minor things, but quite big things, he made the changes. So he deleted right of way and put in the 430 meters, and he put in the different coloration. But tell us if that's wrong. That's the impression I have at the moment.
Well, my lord, I can only tell you what he said in cross-examination. He said that he took the plan from the attorneys at law, and he depicted the drain reserve, and he took it back to the attorney at law. He was cross-examined whether those changes on the plan, those additional changes, were made by him, and he said no. So I could...
I'm very concerned we're going to be island hopping between bits of evidence. We're not necessarily looking at findings. And for my part, it would certainly be helpful within the context of the plans as you're showing them to us, you also to show us briefly, at any rate, the relevant parts of the agreement and the deed.
Yes, I was coming to that, my lord, yes. So if the agreement, is at page 19, and at clause 1 of the agreement,
and it's 15th of May.
15th of May, and clause 1 of the agreement, it would be noticed that they said the vendor will sell, together with the buildings thereon, subject to the right-of-way, which said parcel of land are more particularly delineated and colored pink and brown respectively on the copy of the survey plan dated the 23rd of March, prepared by Mr. Sylvester. So this clause in the agreement is totally inconsistent with the plan, the plan on page 22, because the agreement that the parties had before the written agreement was prepared, the parties had an oral agreement that they would do the survey in order to show the parcel of land which was to be sold. So the recital in paragraph 1 of the agreement does not fit the plan that is attached to the agreement.
No, it doesn't, but it matches more closely, would it be fair to say, the 21st of April
Yes,
plan,
yes, yes.
which came before it.
Which came,
On the dates, you've told us, I think the other one was 21st of April for the second.
yes, yes.
So, and what we see here in this first paragraph is an identification of a precise measurement of 430, which corresponds to the smaller area in the second plan.
Yes.
So you say that the agreement doesn't correspond to the first plan.
Correct.
But there is a measure of agreement between a measure of consistency between the agreement and the second plan, which also preceded it,
yes.
on the dates you've shown us.
Yes, yes.
Which raises the question, Charles.
Yes.
Why they use
Yes.
So, I mean, it might be said that by the time of the date of this agreement, which is obviously a formal agreement between the parties, May 1982, there is full correspondence with the up-to-date plan position, which is A4 on page 28.
Yes.
Both plans precede this. Page 28 is later in time and directly corresponds with the terms of the agreement of May 1982. So as at the date of the formal agreement, I think it's going to be said against you, there's precise correspondence between the agreement and the most up-to-date plan, which is page 28.
Well, my lord, that is the important point. The important point is that if both plans were prepared before the written agreement for sale, and the first plan was signed by both parties, and there was an agreement to sell 2 parcels of land, why the plan of April was not signed by both parties?
Well, anyone reading this agreement would appreciate there are 2 parcels of land being sold,
Yes.
would they not?
Yes, but the evidence is that when Walter Stokes discovered the error in the agreement, he went to the first respondent, and it was agreed that the error would be corrected in the deed. And that is how it was agreed that the conveyance would be for 1 parcel.
I understand you're taking us into the evidence.
Yes.
At the moment, we're looking at the documents with respect.
Yes.
And there is a consistency between the agreement, the second plan, and the deed, is there not?
Yes, my lord.
You accept that in terms of the dimensions, what is agreed to be sold, what is in fact transferred?
There is an
I
inconsistency.
appreciate you're going to come to the evidence, but at the moment you're introducing us to the documents.
Yes.
And you're pointing out differences between particular documents, but would it not also be fair to point out the consistency between the agreement, the deed, and the second plan?
Yes, my lord. And I accept that there was some consistency, but there was also inconsistency in that the written agreement was for 2 parcels of land, but the plan that was attached to that agreement did not match.
I've got that.
Right.
So the problem was that it was actually Plan A2 that was attached to this agreement,
Yes,
rather than the April plan.
correct, my lady. In other words, the parties had these 2 plans before the agreement for sale was signed. But the one which was signed and the plan which was signed identified 1 parcel, and that was the plan which the parties signed, and not the plan with 2 parcels of land.
And can I check that is accepted as a matter of fact, that
Yes.
it was page 22, which was attached to the agreement, that was established as a fact?
Yes, my lord.
Okay. I mean, it is fair to point out on page 19 that in the agreement it refers to a plan dated 23rd of March, which is the date of the earlier plan, but it also refers to parcels which are delineated in colour pink and brown respectively.
Yes, my lord.
Which was not a feature of the 23rd of March. So it is a little bit confusing, but you're telling us that it was established on the evidence that Plan A2, page 22, was the document that was attached.
Yes, my lord.
All right.
My lord, the respondent's case, the respondent's case argued that the conveyance makes sense once one understands that it was intended to convey also the access road. That was the respondent's case. They relied on the written terms of the prior agreement for sale, and that is what I showed the board at page 19. And under clause 1 of that agreement, the agreement was to sell 2 parcels of land, as we pointed out. And the respondent's case is that the larger parcel was 5340 square meters, the main parcel. The smaller parcel was 430 square meters, and the agreement is subject to a right-of-way over the smaller parcel being granted by the respondents to Walter Stokes. That was the respondent's case. The respondent's case on rectification begins and ends there. That was the case. They say that the written agreement was for the sale of both parcels. The conveyance by mistake only conveyed 1. The conveyance makes more sense if one understands that it was intended to convey 2 parcels. So that is their case. But the picture, my lords, was more complicated than that, because clause 1 of the agreement described the land to be sold by reference to the attached plan. The agreement expressly stated that, as described in the attached plan, if the court sees that at, where it is, at page 19, at paragraph 1,
Was there anything on the plan at page 22 that was coloured brown? Because there didn't seem to be anything brown on either plan.
yeah.
I think you told us that the only coloration on page 22 was the shading of pink for the 5340 parcel.
Yes, my lord.
That's correct, is it? We just want to get the facts clear at this point.
All were colored pink on that parcel.
And that's all.
Yeah,
That's all the coloration there was.
All the roads were coloured.
And all the roads,
So the main road
and the main road and the access road were colored beige, sort of brown. But they're saying it was colored green. But on this agreement, it is saying that the big parcel is colored pink and the small color is colored brown.
But, sorry, you're telling us it was coloured brown. The small parcel was coloured brown, is that right?
and the main road itself.
And the main road itself was colored brown.
Right, main road brown, but also what is
Right.
denoted as right-of-way, coloured brown.
Brown, yes, my lord.
Well, that is kind of
I hadn't picked that up.
It looks so from the plan. It looks so from the plan, my lord. I think we'll have to look at the original plans, but it looks so from the plan that is attached.
But that would suggest, going back to clause 1, that even according to the agreement attaching page 22, there were indeed the two parcels to be transferred, because the small parcel, you're telling us now, was in fact coloured brown, so that would make some sense of things.
Well, it appears on the plan that was attached. It appears that the Maracas Royal Road is the same color as the right-of-way.
Yes, but obviously the Maracas Royal Road is not being subject to the agreement,
No.
but the right-of-way is,
Yes.
and you're telling us it was coloured brown.
Yes. So,
May I say, I see that Mr. Strang's showing you a picture. Are we allowed to see the picture?
It's received in my email, so I'll make sure that's forwarded through as soon
I
as.
think that would be helpful.
May I ask whether your opponent has got this before you send us a document?
Yes, I'll make sure that everybody gets the same.
Perhaps you could email it now and then you could have it.
Just follow what's going on.
Is this a photocopy of the original document, a colour photocopy of the original
It's
document?
a colour photo that's just come through from Trinidad.
Oh, good. Of A2.
Yes, and we're looking for A4.
All right. While we're wandering around in the plans, why are they called A2 and A4? Is there a missing 1 and 3, which would throw any light?
it's the documents instead of the plan. I suppose it was a bundle of documents, and the
Oh, are they documents in the disclosure bundle or something like that? Is that why the numbers as it is? Yeah, there's no suggestion of any other plans.
But not as far as the case. There are other plans on the file from the previous deeds, but in relation to the case, these are the two main plans.
Yeah.
So our contention is that the respondent's case, in respect of the agreement, does not match the plan which was signed by both parties. That is a plan on the 23rd of March, 1982.
But you just told us it does, in effect, because it's pink and brown is being sold, and you're pink and brown on that plan.
Yeah. I'm looking at the description, my lord. The plan on page 22 is a plan of a parcel of land colored pink.
Yes.
And that was what was agreed to be sold and to be surveyed to be sold.
There's also no doubt that the right-of-way smaller parcel, as it's being called,
Yeah.
was 430 square metres.
Yes,
Well, it had clearly already been measured before the contract was
Yes.
made,
Yes. And
even though the measurement doesn't appear on the plan. And it wouldn't have been difficult to prove by extrinsic evidence that that was, I mean, if, for example, somebody simply failed to cover the brown, and we were simply construing the contract, it wouldn't have been difficult to identify that as the second plot being referred to. There's no other bit that would be remotely that size.
But anyway, you've told us it's coloured brown, and
yes, but
clause 1 says we're conveying two parcels, the pink one and the brown one.
yes, but my lord, that has to be understood in the context that when it was discovered that the agreement for sale had two parcels of land, the case for the appellant was that the first respondent was approached and it was agreed that the deed of conveyance would only be for one parcel of land. So that even though the written agreement stayed in that recital, it is two parcels of land, one has to consider the evidence in relation to that.
Yeah.
In that, the evidence is, and I will come to that, the evidence is that the first respondent agreed, according to our contention, agreed that the conveyance would be for one parcel of land, and that is the context in which the conveyance was for one parcel of land. And that is why the plan which was signed, which showed that the plan was for one parcel of land, which Mr. Stokes signed, is totally inconsistent with exhibiting a plan for two parcels of land, because the evidence before the court was that Mr. Stokes looked at the plan, he saw the plan was for one parcel, but he did not read the agreement for sale because they trusted each other. And that is why the importance of this case is that one just couldn't look at the deeds and the documents in order to determine what was the true intention of the parties.
But are you saying there are two possible cases for Mr. Stokes to run? The one is that it was always agreed that there would only be the sale of the larger parcel, and whatever was in the written agreement, that was what was agreed. And then when somebody noticed that the written agreement referred to two parcels, it was agreed that was a mistake, and in the conveyance it would go back to being one parcel, which is what had always been the agreement of the parties. That's one version.
Yeah.
The other version is, no, it was initially agreed that there would be two parcels, but after signing the written agreement, Walter Stokes changed his mind, the other side agreed, it was a cheap price, $180,000. They would only actually get the larger parcel for that, and that was why the conveyance reflected that change of mind by everybody. Now, which of those versions is the appellant's case?
The appellant's case is the version that it was always an agreement to sell one parcel of land. The survey was done to depict the parcel of land which was to be sold. And the parties signed that plan in order to, and that is an agreement, the evidence of the respondent shows that. They signed that agreement, and there was a plan which depicted one parcel, and that was what they signed.
Well, it depicted both parcels. It depicted both parcels. The document depicted both parcels of land.
But they described one parcel. The plan was a parcel of land.
And parcel of land colored.
Yes, and what the evidence was, the oral agreement was that they would survey the parcel of land to be sold, and only one parcel was surveyed. because the plan showed only one parcel was surveyed.
Well, the plan suggests that, but everybody knew precisely what the area of the second parcel was by the time of the agreement, which sounds as if that was also surveyed.
I mean, it plainly was surveyed. We've got very precise markings on page 22.
And we know it was 430 square metres.
So our case is that there was one parcel described in the plan, a plan of one parcel, and that was the land which was surveyed. And that was the case the judge had as what the appellant's case was. The respondent's case was that they did not deny, the respondent did not deny that there was disagreement for the land to be identified, what was to be sold. And there was evidence to suggest that that was done, and that is how this survey plan was made. When the written agreement was prepared and the plan was shown, and that written agreement was discovered to have two parcels of land to be sold, Walter Stokes went to the first respondent, and it was agreed that the conveyance would not proceed on that basis. And that there would be a conveyance of one parcel of land. And that we are saying that that showed how the conveyance, notwithstanding the written agreement, was done for one parcel of land. So the conveyance itself, and what I was pointing, the conveyance itself expressly referred to the lands as the first part of this schedule, expressly referred to that. And that was the conveyance which was done.
Where is the conveyance, remind me?
Page 24.
The conveyance is at page 24, and if one looks at the second paragraph, whereas the vendor is seized and possessed in fee simple of the freehold rudiments and premises described in the first part of the schedule hereto, hereinafter called the said lands.
Sorry.
So,
Sorry, I do beg your pardon for interrupting, but page 26, the conveyance conveys both parcels, does it not?
I'm sorry, my lord?
The deed, does it not convey both parcels?
No, the deed of conveyance conveyed one parcel.
Sorry.
It conveyed the said lands, it conveyed one parcel. And it conveyed the said lands as described in paragraph 1, page 24. Whereas the vendor is seized and possessed in fee simple, so and so, the first part hereinafter called the said lands, together with so and so. And when they conveyed it, and whereas the vendor has agreed with the purchaser for the sale to them of the said lands together, now this deed witness it as follows, and conveys to the purchaser so and so the said lands. So the conveyance conveyed one parcel of land.
Which was why the porters were seeking rectification of it.
Yes, my lord.
Yeah.
I've just received a copy, an email with the coloured plan attached.
So my lord, if I may, perhaps this is the appropriate time to state exactly what the respondent's case is, so I could probably show the court, the board. The respondents argue that the conveyance makes sense once one understands that it was intended to convey also the access road, and relied on the written terms of the prior agreement for sale. And I mentioned what clause 1 stated, but I was about to show the court that the,
Just before we move on from the conveyance itself, though, I mean,
yes, so I now will go to the appellant's case, my lord.
no, before we do,
Yes.
I want to ask you a question about page 26.
Page 26. Yes, my lord.
So there's reference there to the second part, and it would be helpful to know how that fits in with the operative part of the conveyance. But if you read within that, it says, all in singular, that certain strip or parcel of land used as a private road, comprising 430 square metres, being portion of the glen, delineated and coloured green on the said plan. Now that suggests that attached to this conveyance actually is the second plan, what we've been calling A4.
Yes.
Yes, my lord.
So what do you say about that? Because that seems that the person who drew up the conveyance did think that they were acting by reference to the plan we've been calling A4.
Yes, my lord.
And which plan was attached to the conveyance?
The plan which was attached to the conveyance is a plan dated the 21st of April 20.
So that's A4 was attached to the conveyance?
A4.
Right.
So in any event, based on A4, the conveyance was still in respect of the first parcel. And we will come to the subject right away, because what it will show that what happened, if you notice in the deed, if the board looks at page 24, where it states subject, however, at the bottom of page 24, subject, however, to the right of passage, hereinafter called the right of way over and along the parcel of strip of land described in the second part of the schedule, here to reserve to Janet Stannard Lovell and registered in the 1967 deed. So the drafter of this was relying upon a right of way which was reserved by Janet Lovell when she sold the main parcel and the right of way in 1967 to Mr. Stokes. But ultimately, Mr. Stokes also bought the adjoining parcel of land, and all that happened before 1982 when the deed was prepared. So that in respect of the deed in 1982, Mr. Walter Stokes owned both the right of way and also owned the whole parcel of land, owned the adjoining parcel, owned the main parcel, and owned the right of way.
Can you tell me which exactly was the dominant tenement under the 1967 deed in relation to that right of way?
In 1967,
Give me the electronic bundle.
the dominant tenement in 1967 was a larger parcel of land, and the Servian tenement was the right of way.
What's the main parcel?
Really?
The adjoining parcel.
What's the electronic page number for the 1967
Right.
deed? I believe it is in the bundle somewhere.
Yes, the 1967 deed, where is that? That's
Because it's that right of way being reserved in the conveyance. It's not a new right of way being reserved.
that right of way does not exist anymore because
It's reserved, though.
yes,
But
in 1982 it did not exist because in 1970 Mr. Stokes purchased. Well, not purchased, inherited the other parcel of land. I could get it.
No, he didn't need the right of way because he now owned it.
Yes, the 1967 deed is at page 71, my lord.
sorry, page
71.
71. Thank you very much.
And if you want,
And the 1970 deed is at page Is it 81?
That's the bit where Stokes inherits the dominant tenement.
And that is where Stokes inherited the dominant tenement. So before the 1982 deed was prepared, Mr. Stokes owned both the dominant tenement and the servient tenement.
So the dominant tenement was the land coloured pink. No? Sorry, I'm getting a bit confused.
No, I think that's the servient tenement.
Really?
The land in pink.
No, surely the servient tenement is that with the right of way over it, isn't it?
Well, because Stokes bought the right of way with the pink land.
Mr. Stokes bought the right of way with the pink land.
Right, that's what I think I was putting to you, that the dominant tenement was the pink land with the right of way.
Yes.
No, because he had to give a right of way to Janet. She retained the adjoining parcel, so the adjoining parcel was the dominant tenement.
The adjoining parcel was the dominant tenement because he had to give a right of way.
Oh, was the adjoining parcel, so,
Yes.
so not the land coloured pink, but...
Yes, so he had to give a right of way to Lovell. And then in 1970, which is in the deed at page 81, he inherited the adjoining parcel.
Right, so he owned both the main parcel and the smaller parcel, but he had to grant a right of way over the smaller parcel to the land immediately to the north of it, the adjoining land.
Yes.
Right. But looking at this,
And then he inherited the land.
then he inherited that land as well, yes.
So basically in 1982, when all these agreements were being prepared and the deed had to be drafted, where it is mentioned in the deed about a right of way, there was really no right of way involved in 1982. And at the trial, there was no issue as to whether the respondents did not have a right of way because they have been using it. And as a matter of fact, in the pleadings of the appellant, accepted that they had a right of way by user.
Right, but Mr. Stokes, in 1982, as I understand it, wished himself to reserve the right of way for the benefit of what we've been calling the adjoining parcel, not least because he had 3 tenants on that property who needed to make use of that right of way through to the Royal Road.
Yes, ma'am. Yes.
So the person drawing up the conveyance were, it might be said, very deliberately seeking to reserve rights of way over the smaller parcel of land, the 430 metres. And it's going to be, I think, said against you that in itself indicates that the smaller parcel, the 430 square metres, was indeed intended to be conveyed to the respondents, because otherwise, why be fussed about a right of way over it? As you say, Mr. Stokes himself owned the dominant tenement, the adjoining land. So, but for the fact that he was conveying, if there was a genuine intention to convey the 430 metres, no one needed to be worried about a right of way for him over that land. I mean, the respondents might need to be worried about it because that was their right of access. But we're looking at what rights they had conceded to other people in the conveyance, aren't we?
But I don't think there was any issue that the respondents did not have a right of way. And the tenants of Stokes had a right of way, and he would have had a duty to ensure that the tenants had a right of way over the land. Because
I think that's what I was putting to you, but doesn't the very fact that he's concerned to reserve a right of way as against the respondents for the benefit of his tenants indicate, or it's one matter indicating, that there was indeed an intention that the smaller parcel of land was to be conveyed to the respondents, because that's what he needs to reserve.
If that parcel of land was conveyed to the porters, then obviously Mr. Stokes would not be able to give his tenants a right-of-way.
Unless he reserved it in the conveyance. But I thought that's what the conveyance ought to do. I'm looking at page 24, which says that certain lands are to be conveyed, subject, however, to a right of passage, which I think everyone has agreed is the right of passage over the small area.
My Lord, one explanation can arise from the fact that the respondents had originally instructed their attorneys at law that both parcels were to be sold. And the attorneys were proceeding on that basis until Walter Stokes corrected the respondents. And it is possible that the attorneys prepare a draft deed conveying both parcels and then amended this draft late in the day to convey only one parcel, but failed to consider all the consequential corrections that were needed.
Right, so looking at the bottom half of 24, it's clear that all that's in the first part of the schedule is the main parcel. So that's the conveyance appears to be limited to the main parcel.
It seems so to me, my lady.
Yes, but granting, but it says subject, however, to a right-of-way across the land in the second part, and that's the smaller parcel. So it doesn't appear to be conveying both parts. It only appears to be conveying the first part, which is the main parcel. But it's actually if you're right, it should say, with the benefit of a right of passage.
Yeah, that's another.
Because you need to have a right to get to the road from the main parcel.
Yeah.
But that wouldn't be the right of passage reserved in the 1967 conveyance.
No.
I've just been looking at it.
Because that's what
it's quite a difficult document because they use the word right of way to describe a piece of land being sold, and then they call the right of passage, i.e. the easement, a right of way. So it couldn't be more confusing if it had tried. But I think I've understood it, and that was a right of way to get from what we call the smaller parcel onto and off the land immediately to the north.
But certainly, if you were conveying only the main parcel, then you would need to also add to that a right of way across the smaller parcel. Yes. Otherwise, you can't get to the road.
Landlocked.
Yeah. But it might be said that my lady's point is another indication on the faith, from the conveyance, that it was intended that, notwithstanding what was written in the conveyance, that the smaller parcel was to be conveyed. So it might be said that there are 2 points that you need to deal with. One is the reservation of the right of way, which seems to be reserving a right of way for the benefit of the adjoining land, not the big parcel, but the adjoining land to the north. And the words subject to suggest that it's the respondents, according to this conveyance, that are affirming that right of way. They're, in effect, re-granting it. And the second point is that the respondents, if they are not acquiring the 430 metres, will have their land isolated from the main road. So they would need, then, a right of way. But the conveyance doesn't reserve a right of way to them. So both points seem to indicate, notwithstanding other features of the conveyance, that the smaller area of land was indeed to be conveyed to the respondents. I'm only raising these points so you can tell us what your answer to them is.
Well, my lord, I know that the deed was faulty, but the important thing is that the deed of conveyance was reflecting and was describing the existing situation in 1982. and that what was being done was the right-of-way, which was in the 1967 deed, and which was expressly referred to, was really not available at that time, because it did not exist. And we know that the deed is faulty in many ways, but in substance, what the deed of conveyance shows, that there was a conveyance of one parcel of land.
Because the first
larger
part
parts of
is
land.
limited, what is conveyed is the first part, and
Yes.
what's in the first part is only the main parcel.
So my,
But your submission is now that there's a serious problem with the deed of conveyance.
no, I don't have a problem with the deed
I
of.
thought you said it was faulty.
Well, it's faulty in ways in which there could be many, many criticisms of how it was done, for example, with the right-of-way. That right-of-way did not exist,
Right.
and they put that as subject of the deed. But what I'm saying, what my submission in the case has always been, that the deed reflected the true intention of the parties for the conveyance of one parcel of land.
Yes, what I'm saying to you is, while your main point is to resist the rectification of the deed of conveyance, that is, you say it's accurate because it's conveying only one piece of land, you at the same time have to say, but even that deed of conveyance isn't accurate because the subject, however, to the right of passage is fundamentally flawed.
Yeah,
Makes no sense.
Yes.
yeah. Well, that's the point made by the Court of Appeal.
You know,
So the reason, well, certainly I've been trying to put these points to you is to bring out that it might be said that there's sort of evidence outside the deed of conveyance itself, see the agreement, that both parcels of land were actually intended to be conveyed, but there's also some evidence internal to the deed arising from the debate that we've been having about the significance of the reservation of the right-of-way, again, which seems to point in towards the idea that the actual agreement was for conveyance of both parcels of land, notwithstanding that another part of the conveyance, as is the whole predicate for this argument, only conveyed the larger parcel of land. So that's what we're seeking your assistance on.
Yeah, well, we know that the conveyancer got things wrong, some things wrong, and we know that the deed is faulty in a number of ways. For example, if it was intended for the conveyancer to convey two parts of land, it failed to do so. Secondly, if it was intended to convey one parcel, it incorrectly deals with the right-of-way. It describes an existing right-of-way. Thirdly, it describes an existing right-of-way when there is no existing right-of-way. But the claim and the issue which the judge had to determine was what was the true intention of the parties in respect of the deed of conveyance. And the other side challenged the deed and to claim a rectification so that it would supposedly convey two parcels of land. My Lord, if I may go to what the appellant's case was, so that I can proceed, my Lord. On the appellant's case, the plan did record, that is the first plan, did record the parties' true agreement because his father, Walter Stokes, had agreed to sell only the main parcel of land. He said that his father made a mistake when he signed the written agreement for sale. At the time the written agreement was made, the respondents presented Walter Stokes with this plan depicting the main parcel, and he signed it. Walter Stokes then signed the written agreement without reading it because he trusted the respondents, and he assumed the terms of the agreement were consistent with the plan. The appellant said that it was he who later noticed the mistake in the written agreement, describing an agreement to sell both parcels of land, and pointed it out to his father. He said that when his father raised this with the respondents, the parties agreed that Walter Stokes would convey only the main parcel and not the access road. They agreed that the conveyance would not be made in accordance with the written terms of the agreement for sale. They agreed that they would delay completion for a few days until after the deadline for completion given in the agreement for sale. That was their way, it seems, of signifying their understanding that they were not bound by or not carrying out the agreement for sale. And the respondents told their attorneys that the parties had agreed to exclude the sale of the access road from the deed of conveyance. These are all matters set out by the appellant at paragraph 13 of his witness statement at pages 478 to 479. That was the appellant's case in short. It was supported by 3 other witnesses. The first was Carl Victor, a retired police officer, and his evidence is at page 559. He died by the time of the trial, but his statement was admitted in evidence under the hearsay rules. And at paragraph 4, at page 561, and forgive me if I don't take you to it because of the time, that Walter Stokes told him about the mistake, and he said he had never intended to sell the access road, and later that he had resolved the problem and was still the owner. The second witness was Nigel Keshenik, a neighbor, and his evidence is at page 564. He said at paragraph 6 of his witness statement that he was present at the discussions when Walter Stokes said he would not sell the access road, and at paragraph 7, he supported that, and at paragraph 8, after the sale, when he visited the respondents, Mrs. Porter would sometimes bemoan the fact that Walter Stokes had not sold the access road to them. And the third witness was an attorney at law, Mr. Uday Ramishan, who bought the land south of the access road in 1992, 10 years later. His evidence was at page 568. He said that when he bought his land, his deed said that the land to the north, that is the access road, belonged to Walter Stokes, and that he established the boundary between his land and Walter Stokes with the help of the surveyor, Mr. Sylvester, at a meeting attended also by the respondents. Mr. Sylvester told him in the presence of the respondents that the access road belonged to the appellant, paragraph 5 of his witness statement. And he said that whenever he wished to use that access road, he would seek the permission of the appellant, and that's at paragraph 7. And he would see the appellant and his family maintaining the access road. That's at paragraph 9. So, my lords and my lady, what was the judge's task, given these contentions? What was the judge's task in order to determine the respondent's claim to rectification of the deed? I would first say what the law was. The burden was on the respondents to satisfy the judge by convincing proof that the deed did not represent the true common intention of the parties. The phrase convincing proof, I take that from the case of Crane and Hegeman Harris, and that is at page 1035 of the electronic bundle, and the passage is at page 1037 at letter H, and it was cited by the judge in her judgment at paragraph 54. At pages...
Did you say 1037?
1037, my lord.
1057?
1037 at letter H. And it was cited by the judge at paragraph 54 of her judgment, and that is where I got the convincing proof. And the need for clear and convincing evidence was also emphasized by the court in the case of Fowler and Fowler. It's a 1059, and the passage I want to refer the board to is a 1065.
So it was common ground throughout that actually the deed of conveyance had only conveyed the main parcel and not the smaller parcel.
I'm sorry, my lady?
It was accepted throughout, and this was the basis of the porter's claim, that the conveyance only conveyed the main parcel and
Yes,
did
madam.
not convey
Yes.
the smaller parcel.
Yes, my lady.
May I ask you one other point about that, and that is this. The deed of mortgage contemporaneously executed with the deed of conveyance involved a mortgage of both parcels, is that right?
Yes, my lord.
And what, in terms of the documents again, what's your position in relation to that?
Well,
What's your submission in relation to the mortgage?
it was never raised at the trial and never pleaded that the judge did not consider the mortgage issue. As a matter of fact, this is the first time that issue is being raised. And it was not pleaded, it was merely disclosed, but not referred to in evidence. And not exhibited in any witness statement. There could have been no
It
cross-examination.
wasn't even disclosed.
It was discussed.
It was
was
merely
disclosed.
just disclosed,
Right.
but not exhibited as evidence. It was not part of the cross-examination.
So they weren't relying on that as
It was
support.
not relied upon at all. And so it's unfair for it to say that the learned judge didn't consider that. And if that was raised, then there could have been, we could have asked for disclosure, we could have asked for the lawyer's files and matters like that.
You were on strong irrefragable.
I was Fowler and Fowler at page 1065. And at page 265, it states, it is clear that a person who seeks to rectify a deed upon the ground of mistake must be required to establish in the clearest and most satisfactory manner that the alleged intention to which he desires it to be made conformable continued concurrently in the minds of all parties down to the time of its execution. And as for the test to be applied to determine the party's intention, in the light of the recent decision of the English Court of Appeal in FSHC Group Holding, at Glass Trust, that is at page 1114, at paragraph 154, and before I read it to the board, I will say, the test seems to be that if in executing the instrument, the parties were purporting to give effect to a binding prior contract, that the intention of the parties is to be objectively ascertained by looking at the terms of the prior written contract. And if the instrument does not give effect to that intention, as objectively assessed, it may be rectified. In all other cases, the test is a subjective test, and the court is not limited to considering the party's objective intention as expressed in the prior contract, but may consider all relevant extrinsic evidence, including evidence demonstrating the subjective intention of the parties. And that evidence can include evidence of subsequent conduct or statement of the parties for the reasons explained by Lord Justice Leggett, as he then was, at paragraph 154 at page 1114.
Yes.
Page 1114.
And why do you say that this is a different case from we have an objective agreement for sale for 2 parcels of land, so we just look across
Well, the objective,
to the objective conveyance?
well, the written
And see there's a disparity and therefore rectification.
Well, the written agreement is ambiguous because it's inconsistent with the plan which was attached. The plan which was attached was signed by both parties, identifying a parcel of land, and therefore...
I think we've had some difficulty understanding whether that's actually made out in relation to those plans.
Well, the appellant's case is because it was the appellant's case that the parties to the deed were not purporting to give effect to the written agreement for sale. They had acknowledged that clause 1 of the agreement sale was a mistake.
So you're really asking us, in effect, to rectify the agreement for sale?
No, my lord. I'm not asking to rectify the agreement for sale.
Well, you're saying that agreement for sale did not represent the true agreement of the parties?
No, we're saying that the judge had before her the question of an ambiguous agreement for sale, which was inconsistent with the plan which was attached to it. And there was evidence to show that agreement, that written agreement for sale, when it was discovered that it was for 2 parcels of land, there was an oral agreement between the parties.
But if we were just dealing with the interpretation of that contract, the contract of sale, that is an objectively agreed contract. How can we go behind that other than by invoking a doctrine of mistake and therefore seeking to, in some sense, rectify it?
Well, there's no need to rectify if the parties agreed it is not to bind them. And this case is that there was agreement for an agreement between the parties that they would not be bound by that agreement because there was a mistake, there was an error.
Might the point be this, Mr. Maharaj? In this case, there is an agreement for the sale of 2 plots, or 2 parcels, which, although not by any means perfect, if it was simply a question of enforcing that agreement, the small parcel would be identified as subject to the sale recorded in that agreement. In such a case, a party who wishes to avoid a disparity in the later conveyance being put right in accordance with the binding agreement probably bears the burden of showing that the agreement was varied. I mean, that's what you came to court to do, I fully accept, but it's just a question of maybe where the burden lies.
Well, I did that, and the judge accepted.
Yes.
The judge accepted, but the burden still is on the respondent to provide convincing proof.
Is that really the case, if they've got a binding contract that gives them what they want?
Well, the binding contract...
Why doesn't that discharge that?
Well, the contract is not binding, because the contract was signed, but then there was an agreement to say that it would not be binding.
Exactly. So they come to court and say, I've got this binding contract. The burden then turns to you to say, oh, no, it was varied.
And the evidence was supported by evidence that the judge found, including documentary evidence. Judge said that the agreement was the judge found that the agreement was ambiguous.
Is the argument it was varied, or that it wasn't actually their agreement at all?
Yes, in effect, that is what Mr. Stokes said. It was not his agreement.
Yeah.
It was not his agreement.
So you are seeking to invoke something like that agreement was based on a mistake?
Yes, he said so. That was the case.
So my Lord Briggs is putting to you that although the overall burden of proof rests on the other side to prove rectification of the deed, they at least prima facie meet that burden by showing, in relation to there being an earlier objective agreement, and then the burden shifts to you to show why that objective contract of sale shouldn't be regarded as binding.
Well,
Isn't that right?
well, even if I accept that, and I, with the greatest respect, I accept that,
Yeah.
the evidence was there, and the judge
You say
found-
you've met that burden?
Yes,
Yeah.
met that burden.
Sure. I mean, the way it was actually put at the trial, as I understand it, was that your client, or the deceased, said, let's vary it. The other side said, no, it'll get us in trouble with the mortgage offer.
Yeah.
So you say that the parties agreed to let the contract expire
In
and then
layman
simply
terms.
to go straight to a conveyance,
Yes.
otherwise than pursuant to the enforcement of the contract.
Yes.
That's the case that was advanced at trial.
Yes.
Yes.
And which the judge accepted.
Which the judge accepted.
Yeah.
So we submit, I wouldn't read paragraph 154 because of time, I take it. So in the present case, the judge was not faced with the simple task of objectively assessing the intention of the parties by considering the terms of the agreement for sale. This
She
is
regarded her task as
Yes,
looking at the evidence in the round.
much obliged. This is because the appellant's case was that the parties to the deed were not purporting to give effect to that agreement. And the parties had acknowledged it, and that they were not bound by it, and they agreed that the deed was not carrying out the agreement for sale. And we submit that in any event, the judge in any event had to look beyond the terms of the agreement for sale to find out what the parties had agreed, because the written agreement was ambiguous, as we have seen that the signed plan was not consistent with the written terms of clause 1. So, in the light of those issues, questions for the judge included: 1, did the parties acknowledge that clause 1 of the agreement for sale was a mistake? And did they agree not to be bound by the written terms of the agreement for sale? And then that leads to, were the appellant's reasons for saying that clause 1 was a mistake borne out by the circumstances of the making of the agreement for sale? And what did the parties actually agree? In the light of those inquiries, what had the parties actually intended by the deed? Those are the questions which the judge had to decide. Those questions entail factual inquiries, which were very much the province of the trial judge. They required the judge to make findings of fact after the consideration of extrinsic evidence beyond the deed and the agreement for sale. And how did the judge direct herself? The judge understood and carried out her task correctly, we submit. She did not have the benefit of the judgment in FAHC clarifying the distinction between the subjective and the objective tests, but she nevertheless directed herself in accordance with the authorities consistent with the principles as expounded in FSHC. And because of time, I can just refer to paragraph 53 at 294 of a judgment. It's the Master of the Rolls in Murray and Parker, and there was an error in her reporting, a typographical error, but what it says at page 1140 is, in all cases, the real agreement must be established by evidence, whether parallel or written. If there be no previous agreement in writing, parallel evidence is admissible to show what the agreement really was. If there be a previous agreement in writing which is unambiguous, the deed will be reformed accordingly. If ambiguous, parallel evidence may be used to explain it in the same manner as in other cases where parallel evidence is admitted to explain ambiguities in a written instrument. Having surveyed the authorities, the judge set out her approach in the evidence at paragraph 56 at page 297. You could find it for me? Just find it for me. Paragraph 56. Sorry. 1 second, please. I'm just trying, because this is an important passage which at paragraph 56 of a judgment at page 297, consistent with the principles outlined in the authorities above, I examined the evidence in this case in order to determine what was the common intention of the parties prior to the execution of the deed of conveyance. I bore in mind during this exercise the fact that the real agreement or intention of the parties could be evidenced by both written and parallel evidence, that where there was a previous agreement in writing, as in this case, if such agreement was ambiguous, parallel evidence was admissible to explain any ambiguities in the written document. That is consistent with the authorities and the judge's assessment and findings. The judge's assessment of the evidence and the reasons for rejecting the respondent's claim are at paragraphs 57 to 66 at pages 297 to 301. I would not go through all of them. I will just try to summarize. I'll pick out the factors she identified as important and which justify the findings. First, she rightly identified the original March 1982 plan signed by the parties as important. It was common ground that when Walter Stokes orally agreed to sell some land to the respondents, the parties agreed to instruct a surveyor to make a plan clearly depicting the land to be sold. That was the first respondent's own evidence, as noted by the judge at paragraph 57, 297 to 298. What the first respondent had said was at paragraph 11 of his witness statement at page 599. And this is what he said. Mr. Stokes and I agreed that it would be best to have a survey plan prepared showing exactly the land my wife and I were buying from him. Accordingly, I engaged Mr. Sylvester to prepare a survey plan showing the lands, and he did so. It was common ground that all the parties, including the appellant, attended the survey and pointed out to Mr. Sylvester the land to be sold. See the appellant's witness statement at paragraph 10 at page 477. He said, I was present at the survey which was conducted as requested in March 1982 by Vincent Sylvester. My father and the claimants were also present.
I'm so sorry, I missed that page.
Page
477.
477,
Thank you.
paragraph 10. The first part of the appellant's paragraph 10 was not challenged or disputed. He and all the parties to the agreement were present for the survey. He was challenged on his evidence that his father at the survey repeated his refusal to sell the access road. Mr. Sylvester went away and produced a plan, which was the plan of March 1982, document A2, which we have seen at page 22. As we have seen in that plan, it was said to be a plan only of one parcel of land. It colored pink, measured, and described only the main parcel. And the parties then signed the March 1982 survey, indicating their approval of it. On the evidence of the plan, therefore, at the survey, the parties only pointed out to Mr. Sylvester one parcel of land to be included in the sale. That is consistent with the appellant's account of the agreement. The judge took the same view at paragraph 61, at page 300. She said, I consider on the evidence of the survey plan, A2, that what the parties really intended was that only parcel 1 was to have been sold to the claimants. She was entitled to make that finding on the evidence before her. Second, the judge rightly identified another important factor in the fact that by the time the agreement for sale was made in May 1982, the respondents had obtained the amended plan made in April 1982, which depicted and measured both parcels of land. That was document A4 at page 20. In the written evidence, both the first respondent and Mr. Sylvester had said that he amended his plan in August 1982. But in oral evidence, both accepted that it was in April 1982. Mr. Sylvester's admission is at page 726. Mr. Porter's admission is at page 712. Indeed, given the fact that Mr. Sylvester wrote on it in hand 21/4/1982, there could realistically be no other conclusion that it was April. I would add that this plan is the first record of the access road being measured with an area of 430 square meters. And we know that the area of the road in meters was measured before the agreement for sale in May 1982, because it is described by the area in the agreement. So that also tends to suggest that this plan was made before the agreement for sale.
But I don't see why that helps you.
I'm sorry, my lady?
Why would they measure that land?
We do not know why it was measured, but that was the first time we knew it was measured. The fact that the plan was amended to describe, depict, and measure both parts of land before the agreement for sale is important. If, as the respondents were contending, the agreement was for the sale of both parcels, and if they had a plan which depicted and measured both parcels, the judge was bound to ask herself why the respondents had instead presented to Walter Stokes for his signature a plan describing only the main parcel. She answered the question at paragraph 65 at page 301 of her judgment. At paragraph 65, she said, I am also of the view that it was open to the claimants to seek to obtain the record. Sorry, I read in the wrong paragraph. 61.
No, 65.
Sorry, 65. 65. From the totality of the evidence before me, I do not consider Mr. Porter to be a credible or reliable witness for the reasons stated above. Additionally, and very importantly, I formed the view on the clear evidence before me that the claimant had prepared 2 survey plans before the execution of the agreement for sale, one depicting the first parcel only, and the second depicting both parcels with a drain reserve, in order to induce Mr. Stokes to sign the agreement for sale. A2, which only depicted the first parcel, was drawn to his attention. He signed that plan at the same time that he signed the agreement for sale. A reasonable inference to be drawn from these events is that Mr. Stokes was never shown A4, and this was deliberately planned by the claimants. In my view, the only reason for this deception was that Mr. Stokes was adamant that he would only sell to them the first parcel and not the second parcel.
That's a finding of fraud. What was fraud pleaded in the defence? That's a finding of fraud by Mr. Porter. I'm simply asking whether fraud of that kind was pleaded in the defence.
But she did find that...
I hope I'm not saying anything contentious by saying it's a finding of fraud. I mean, the judge describes it as a deliberate deception.
She didn't say fraud, she said deception, but...
Well...
I'll get Mr. Strong's check.
Could I ask a question on top of that? Was it put in cross-examination to Mr. Porter that there was deliberate deception of that kind?
I don't remember. I can ask my junior to check that. I can't remember that, but I don't think that was put. But I think it was put that he was not speaking the truth.
So the judge thought that both they'd got drawn up the 2 plans, they'd got Mr. Stokes to sign the one that showed just one parcel, but yet it was agreed that the one that was attached to the written agreement was also A2, the signed one, and not A4.
The third finding, the judge examined the first respondent's original statement that the April plan, A4, was made in August. The parties are delayed in completion in August for a few days.
Are you reading from something? Is it Is it something in front of us that you're reading from at the moment, or is it, this is your submission?
I'm reading from my notes for the
Thank
submission.
you.
Yeah.
Could you give us the page reference to where Mr. Stokes said in his witness statement that the Plan A4 was dated August?
Yes.
Porter, I'm so sorry, Mr. Porter.
Yeah. You could help me.
Yeah, it would be helpful because obviously it's an important point. You pointed us to cross-examination of Mr. Porter where he accepts it's April. Thank you.
That is
19 and 20, page 601. Page 601 is the evidence issue.
page 601.
Thank you very much.
Paragraphs 19 and 20. And in, you want to know when the 21st April?
Right, because his case was that it was, that the point about adding the drainage in only arose in August when they went.
Yes, you were saying it only arose in August, but in cross-examination, his cross-examination is at page 705 it starts. And,
I'm sorry, I can't hear you.
Sorry?
Could you repeat the page, please?
The page, his cross-examination starts at page 705.
705.
Yes, but the cross-examination on the 21st of April would be at page
712, I think you told us. I think it starts at 712 and then it goes
Yes,
on.
yes, yeah. The other matter which the judge assessment found, the judge examined the first respondent's original statement that the April Plan A4 was made in August. And that is the reason they gave for delaying it for a few days after the original deadline was the 18th of August, 1982. Now, the first respondent disputed the appellant's account of the reasons for the delay. He said that it was to allow Mr. Sylvester to amend the survey plan to depict the drain that runs main parcel. But Mr. Sylvester amended plan depicting the drain was made in April, and Mr. Sylvester admitted that when he gave evidence. And that admission can be found for Mr. Sylvester at page 726. Look at the bottom of the plan, the 21st of April, 1982, 21st of April, that would be the date you amended it, not so. That would be the date I signed the amended plan. The date you signed would be around the time you amended it, yes. So I understand the middle of August is not accurate. Mr. Sylvester, as far as you can recall, the only amendment you did on that plan was to insert the drain passageway, not so? Yes, it was. So in respect of the A4 plan, he didn't make any other amendments. And the judge also, in a judgment at paragraph 60.
Are you suggesting therefore that somebody else did?
Well, I did.
I mean, we know there were all sorts of amendments.
There were all sorts of amendments.
And either Mr. Sylvester is perfectly genuine,
And there has been no
30
explanation.
years previously.
The point is that there has
Or are
been
you
no.
advancing a case that somebody else doctored?
No, but there has been no, my lord, all that I'm saying what the evidence is, and there has been no explanation from the evidence as to how the amendments were done, who did it.
No.
What the evidence suggests is that the survey plan was in the bosom of the attorneys at law and also in the bosom of the first respondent. But I'm not making any suggestion, but that is the evidence.
The significance of the date, as I understand it, is that the change to the drainage was said by the Porters to be the reason why completion did not take place before the written agreement had lapsed.
Yes, yes.
And that would require that drainage only to have been added to the plan in August.
Yes.
Whereas if it was in April, then there was no particular reason why completion had not taken place before, by the date specified in the written agreement, and that then opened up the possibility of your client's explanation as to the delay being the correct one.
Yes, my lord. The judge also noted that it had been open to the respondents to seek to obtain the conveyancing file of the attorneys at law, but they had not done so, and that's at paragraph 63 of the judgment. She noted that this file could have answered the questions raised over the respondent's account of events. That was an important factor given the burden on the respondents to supply her with convincing proof. The same attorneys who had drafted the deed were now representing the respondent at the trial. The judge was right to find it remarkable that neither the conveyancing file nor an explanation for its absence has been put before her. Fifth, the judge accepted the evidence of the appellant's witnesses that Mr. Stokes had no intention of selling the access road, and that after the sale, the respondents showed that they knew that Walter Stokes and his successors still owned the access road. See paragraph 64 at page 301 of a judgment. Now, those were the relevant findings that was confirmed in the decision FHC. The judge was entitled to look at the subsequent conduct and the statements of the parties if those shed light on their actual intentions. And they were findings open to her based on an assessment of the witnesses, not only of the appellant, but also of Mr. Ramishan and Mr. Pechnik. Those
Can I just ask on paragraph 64, I wonder whether it might be said that the judge has left out of her assessment there the obvious interest that the respondents would have in having access to the land that they were acquiring over the smaller parcel.
Sorry, my lord, paragraph 64.
Page 301. She's talking about the interest of Mr. Stokes in retaining the right-of-way.
Yes.
And is saying, and therefore he wouldn't have sold the land, the smaller parcel. Does she bring into account in her judgment the obvious interest that respondents would have in having access to the land that they were acquiring?
Yeah. I think she's just accepting the evidence of Mr. Stokes that they had no intention of selling the right-of-way.
Yes, thank you.
Since all the other tenants on the property use it to gain access to Maracas Road. And
but there hadn't actually been any problem with respondents using that land to get.
And as a matter of fact, I don't know if the board wants to see it, but in the pleadings, Mr. Stokes had pleaded that in any event, the first respondent had acquired a right-of-way by prescription because of the length of time under the Prescription Ordinance Act.
You mean after he bought the larger plot, the larger parcel? Yes, because well, no, I think it might have gone earlier than that, mightn't it?
Come by necessity.
Because he was wasn't he living there earlier?
And there was an easement of necessity.
Yeah.
So that in any event, there was no problem of the right-of-way for Mr. Stokes, for the first respondent.
For the porters, so it was accepted that the porters, whatever had been conveyed to them, had acquired by prescription a right-of-way over the smaller parcel because they would need that to get from the main parcel to the road.
Sorry, is that right? It's maybe my fault. I thought that the claim based on prescription had failed. But
that was for the triangular.
The triangular. Was there a claim based on prescription to a right-of-way over the smaller area of land?
Yes.
Sorry, you're nodding. Yes, there was. And,
yes.
And I asked, did it succeed?
we had pleaded, is that what he's asking?
Claim over for possession of a small triangular.
Yeah, there was a claim in respect of a small triangular portion of land, but it wasn't a right of way.
Right. So was there any case of acquisition by right of prescription for the Stokes of a right of way over the smaller portion of land?
Porters.
Porters. Sorry, I keep mixing it up. I'm so sorry.
No, there was no claim, but in the pleadings, and I think it's at paragraph 57 of the defense at page 117, it was pleaded by the appellant that in any event, having regard to the prescription ordinance, Mr. Stokes had an easement over the said right of way.
No, the
And
porters had an
I'm only mentioning that because there was no issue.
I think what you're trying to say is that when the porters were raising the point, well, of course we would have bought the smaller parcel because we need to get from the main parcel to the road, and that was in support of their rectification claim. Mr. Stokes said, no, you don't need to have the smaller parcel because I accept that through necessity or by prescription over the long time that's happened, you have got a right of way over the smaller parcel that I still own, but you can use to get from the main parcel, which I say is the only bit of land we sold to you, to the road.
Right. And where do we get that from on page 117, just so that I can follow this?
I don't think it's 117.
I think it was Mr. Stokes.
Page 1, what that,
57.
yeah.
You were looking for 57.
Yes, I'm looking at for 57.
57.
57. G, 57 at G. The claimants have known at all material time that Walter Stokes and thereafter the estate of Walter Stokes owned the said right-of-way and that they had acquired by operation of law an easement over the said land on which exists the said right-of-way. The defendant contends that at the time of the said agreement of sale was signed, the claimants had already acquired by operation of law, and in particular section 2 of the prescription ordinance, the laws of Trinidad and Tobago, an easement over the said lands on which the right-of-way exists.
How did that work? I can see the assertion. I'm baffled as to how that works. They've been living there as tenants, have they? On part of the larger plot.
I mentioned that because I wanted to say at the trial, this issue of the right-of-way was not an issue at all.
I understand.
Yes.
But it leaves one wondering what a prudent conveyancer would have advised them at the time of the transaction.
I think prudent conveyancers don't seem to have figured in this story, I'm afraid. What we're missing.
I'm sorry, we've asked you a lot of questions, Mr. Marhaj, but you're very
So I think the last finding is that the judge accepted the evidence, and therefore we are submitting that these 5 factors all support the judge's conclusions, which were as follows: that the respondent's evidence fell short of the convincing proof necessary to pursue it, and that was paragraph 60 of a judgment; that at the time the true intention of the parties was that only the main parcel should be conveyed, and that is paragraph 66. In summary, the judge properly directed herself and made findings that were open to her on the evidence which were more than sufficient to dismiss the respondent's claim. There was no reasons for an appellate court to interfere with her finding. How many minutes I have?
2 or 3.
How many minutes?
2 or 3.
My lord, I notice that time is against me. I only have 2 or 3 minutes. If I may summarize, and I was now about to deal with the Court of Appeal reasons for interfering, and
Well, I think you can take that we know what their reasons for it.
Okay, my
If
lord.
you've got some very specific criticisms.
Okay.
Now-
If I can just identify three main points, my lord, without exceeding my time. First, the Court of Appeal misunderstood the evidence and the issues in the case. In particular, it's misunderstood the importance of the first plan and the fact that, as the judge found, that plan represented the parties' actual agreement. And rather than address the issue of whether Clause 1 of the agreement for sale was a mistake, it proceeded on the erroneous basis that there was no controversy that the agreement for sale was intended to convey both parcels. Second, which is related to its misunderstanding of the issues, it found that the test of the parties' common intention was an objective test only, informed by the contractual documents. As a result, it gave itself too much of a license to interfere with the judge's findings, saying that the advantage to the trial judge in having conducted a trial of all the evidence and heard all the witnesses was minimal. Third, it wrongly found that the terms of the deed led to only one conclusion, that the parties must have intended to convey the access road. That was wrong because there were other explanations for the inconsistencies in the deed. And in our submissions, therefore, we submit that the judge approached her task correctly. She understood the issues which she was required to address and made findings of facts which were properly open to her. The Court of Appeal, by contrast, made critical errors of analysis and law, and with respect appears to have started from the presumption that the respondents were correct. It did not establish that the judge had gone wrong, and it identified no good reason for interfering with her findings. Go ahead, tell me something. Yeah. Can I take 10 minutes and have a shorter reply, my lord?
Of course.
Yes.
We've asked you an awful lot of questions.
Yes.
So it will involve some cutting into your reply.
Right. I'm much obliged, my lord. I'm much obliged. So the first error of the judge is that the Court of Appeal fatally misconceived the issues and the relevance of the evidence. This is demonstrated in particular by Justice of Appeal Barrow's discussion on the effect of Mr. Sylvester's survey plan at paragraph 85. And because of time, I could just refer at page 428 at paragraph 85(1). The Court of Appeal stated, at the time of the execution of the agreement for sale, there was no controversy that both parcels were being sold. And at page 429, at paragraph 85(2), up until that time, there was no contention between the parties that both parcels were for sale. That was entirely wrong. It ignores the appellant's case that there was a controversy and that the agreement was a mistake. And it ignores the crucial importance of the judge's finding that the appellant was right and the first plan, which described only one parcel, represented the party's true intention. The second error of the Court of Appeal, the Court of Appeal's second error derived in part from its misunderstanding of the issues, and also from the following the dicta of Lord, and also in following the dicta of Lord Hoffman in Chartbrook and Pesce on Holmes. Not having the benefit of that judgment, it held that the question for any rectification claim was what an objective observer would have thought the intention of the parties to be, whether there was a binding prior agreement or not. See page 413, paragraph 31, subparagraph 4. It found that the issues in the case called for an objective test of the parties' common intention, and that the contractual documents were paramount. Thus, at page 431 at paragraph 88, he stated it is an objective rather than a subjective test, and it is to the documentary evidence that we must first look. At page 410 at paragraph 23, his lordship stated that the advantage of the trial judge was minimal. and as he had described in paragraph 26 of his judgment at page 411. But my lords and my lady, we have seen that these documents did not point all one way. They raise questions of the respondent's case, and the inconsistencies in them call for explanation and extrinsic evidence. The third main error is that the Court of Appeal found that the terms of the deed were only consistent with an intention to convey the access road as well as the main parcel. Justice of Appeal Barrow said the references in the deed to the right-of-way only made sense if the parties intended that the road be conveyed. This was at page 427, paragraph 79 to 82. He proceeded to find that the parties to the deed must have intended that both parcels be conveyed. We submit that the Court of Appeal was wrong. It could not properly rely on the deed to reverse the judge's findings unless the terms of the deed could really only be explained by a continuing common intention to convey both parcels. But the facts of this case readily offer alternative explanations for how the words treating with the right-of-way ended up in or survived in the deed. One explanation arises from the fact that we know that the respondents had originally instructed the attorneys at law that both parcels of land were to be sold, and that is apparent from clause 1 of the agreement. And the attorneys were proceeding on that basis until Walter Stokes corrected the respondents. It is possible that the attorneys who prepared a draft deed conveying both parcels and then amended this draft late in the day to convey only one parcel, but failed to consider all the consequential corrections that were needed. Another explanation could be that the conveyancer simply did not understand the relevance or effect of the right-of-way. The parties intended the main parcels to be conveyed together with a right-of-way, but the conveyancer mistakenly expressed it instead as being subject to a right-of-way. We know from the terms of the deed that the conveyancer did produce a conveyance which we describe as faulty when on any view it had inconsistencies in it. And we have already seen that he did not understand the position as the right-of-way because he wrongly wrote that there was an existing right-of-way. We submit those are the kind of mistakes which can be...
Be clear on the right-of-way. There needed to be a right-of-way, whichever, whether or not the small parcel was conveyed. If the small parcel was conveyed, then there needed to be a right-of-way reserved for the benefit of Mr. Stokes and his tenants on the adjoining land.
Definitely.
If the smaller parcel was not conveyed, then there needed to be a right-of-way for the benefit of the porters, so that they could get from their mainland to the road.
Mm-hmm.
So that land needed to be a subject to a right-of-way in both.
Yeah, but it was wrong to describe it as an existing right-of-way.
Yes, I understand that point. I'm just trying.
Well, sorry, it didn't. If Mr. Stokes was retaining the smaller parcel, there didn't need to be a right-of-way as such, did there? Because he just owns then the whole of the adjoining land and the smaller...
The porters.
The porters. Sorry, do I have a...
There need to be one for the tenants.
Yeah, then it would be...
There need to be one for the tenants.
You wouldn't need it for the right-of-way for the tenants.
But the problem is not just grant or reservation. The right-of-way which was in fact reserved was the right-of-way in the 1967 conveyance, which was for the benefit of what is now the adjoining land.
Which no longer existed.
No, but it can be recreated by reference as it was in the document.
If there was such an agreement.
Yes, but sorry, what I'm suggesting to you is that as a matter of construction of the deed,
Yeah.
it's not just the words reserved, it's the reference to the origin of the right-of-way being in the 1967 deed. Because then if you look carefully at the 1967 deed, which one assumes the conveyancer would have done, one knew where that right, what the dominant tenement was, and it wasn't the land being sold, it was the land being retained.
But it seems as though what the drafter did, it merely referred to that, but didn't understand that the right-of-way.
Maybe the
yes. And if it had to be recreated, the drafting would have been different.
We're grabbing more of your precious time.
Yeah. My lords and my lady, in respect of the mortgage documents, I made a point, and it's be subject to what my friends say, I will respond to it.
That's your point, that they weren't pleaded or raised.
I'm making the point that it was not an issue in the case. There was no evidence. The judge didn't have an opportunity of dealing with it. We did not have the opportunity to cross-examine, to get disclosure, etc. And the first time it is being raised is here.
Thank you.
Unless I could, anything.
Well, the only further assistance which we would welcome, but by all means give it during your reply, is whether there was any cross-examination of Mr. Porter along the lines that he had undertaken a deliberate deception of Dada.
It was not pleaded.
No, I'm asking also whether there was any cross-examination about it.
No.
Okay.
And I would certainly welcome confirmation.
It was not pleaded, and I do not think it was an issue which arose at all.
I would certainly.
Just on that, but I might be wrong, scanning forward from page 715 for about 5 or so pages, I'm not inviting that we take up time now, but I think what was put to him was that his evidence was quite wrong. But it wasn't put to him that he'd embarked on a deliberate attempt to deceive Mr. Stokes.
Which is what the judge found.
Which is what the judge found. And indeed, it was being put to him that there was, at that time, a relationship of trust between both sides.
Yes.
That was so rather the opposite of putting to him a case of deliberate fraud. Anyway, don't take up time on it now, but I draw that to your attention in case you want to say something about it in reply.
Certainly for my part, I'd welcome confirmation of any agreement there may be in relation to this document you've sent us through by email, as to what it is and what it shows.
Where's a copy?
Okay. I will look at that during the.
I think it's a colour version of Plan A2.
That was my understanding.
Yes. While we're on the subject, whoever's doing this wonderful job for us out in Trinidad, if we could possibly have a colour version of Plan A4 and of the plan annexed to the 1967 deed, that would be very helpful.
Yes, my lord, I can answer about Plan A4. On our side, we don't have a colour version.
Okay.
We only have that which was disclosed. Whereas the colour version we sent you of Plan A2 is an original one held and kept by Mr. Stokes, which is why you see it doesn't have signatures on it. It predates the signature on for the purposes of the agreement.
That's very interesting. Thank you. Yes.
Was that the last?
I'm so sorry, Mr. Strang. Just to understand then the relationship between what you sent us and Plan A2, there was a photocopy taken, and then that was what was signed. I'm now a little
that I can't answer without further instructions.
Could you provide us with that information during the course of the day, if at all possible?
Yes.
Yeah, thank you.
What they want?
67.
Okay.
Thank you.
Much obliged, my lord.
Now then, Mr. Benjamin.
My lords and my lady. My lords, it might be helpful for me to begin right where we just left off and to affirm for the board's consideration that not only was the allegation of deception not pleaded, it was not the subject of any cross-examination whatsoever. And therefore, to the extent that Mr. Porter, Mrs. Porter, now deceased, and possibly their attorneys were implicated in something that was dishonest or fraudulent, it was an unfair finding made by the trial judge. And the Court of Appeal were entirely right to point that out in their decision. And even assuming that the other points that the Court of Appeal made didn't go in my favor or didn't occur, that point alone would have been a proper basis for them to have reconsidered the judge's findings, carefully considered the totality of the evidence in general, but much more particularly the documentary evidence, in order to ascertain whether the porter's claim for rectification was properly made out, as indeed they did. That allows me to go to my second and related point, which is...
Just before you do,
Oh, I'm sorry, my
do
lord.
you have the page number where the Court of Appeal made that finding? But it was an unfair, where the Court of Appeal concluded it was an unfair finding. Come back after the short adjournment if you'd rather not.
My lord, yes, if I can come back, I
Yes,
thought
by
it
all
was
means.
around paragraph 85. I was doing it from the top of my head in answer to what my friend just said. But I will find the relevant paragraph.
Thank you.
My lords, I was going to say something about the documentary evidence. You have had the benefit of a fascinating exchange with my learned friend, attempting to get to the bottom of the documentary evidence, as it were. And when you come to consider the learned judge's analysis, the one thing that will be conspicuous by its absence is any such attempt to get to the bottom of the documentary evidence and to analyze it in the way that my learned friend and the board has engaged with him to do so. But much more importantly, or equally importantly, I should say, as far as the documentary evidence is concerned, is what the learned judge did not do to grapple with the sequence of events, or the sequence of events as revealed by the unfolding of the documentary evidence. So that while my friend starts or commences his oral submissions to you by reference to the survey plan of March of 1982, and then went at A2, and then went to the second survey plan of April of 1982. Both of those precede the contract of sale.
Would you accept that now, that the April 1982 plan is correctly dated?
More than that, my lady, in my written case, I try to argue rather faintly that the Court of Appeal's decision to say that it was August is right. I will not pursue that in my oral submissions. So, my lady, yes. Yes. And that ties in, if I can say with respect, ties in with my first point, which is that what the learned judge had before her was evidence of faulty recollection and not deception or fraud. And that, in fact, was the gist of my learned friend's cross-examination, both of Mr. Sylvester and of Mr. Porter, because he began in his cross-examination by putting to them, I appreciate that these are events that happened some 30 years ago, the trial having taken place in 2011, 2012, and of course, these plans having been drawn up in 1982. So we say, my lady, that the correct sequence of events, as revealed by the documentary evidence, which the learned judge did not grapple with. In other words, by May of 1982, the parties' intention was that both parcels were to be conveyed. That is communicated to each other by the unambiguous, with great respect to my learned friend, the unambiguous language in the agreement for sale, and any ambiguity that there might have been, residual as it were, as of March of 82, was completely destroyed and set aside by April of 82, and certainly by May of 1982. In other words, by May of 1982, there was no ambiguity and no, to use the language of the Court of Appeal, no controversy between the parties as to the parcels that were to be conveyed.
Why did your client come up with this version of events about going to see the attorney in August, and then they had to make the change to the plan to add the drainage reserve in August?
Well, my lady, that's what he remembered. So that if you test his recollection, so there are two elements to it. The first is the date, which he clearly got wrong, but the second is the substance. So if you want to test the accuracy or reliability of his recollection by reference to the drainage plans and the drainage rights, it is clear that they are there in A4, the amended plan. And not that the board needs the benefit of what other judges say at first instance, but I included in the bundle Mr. Justice Legatt's decision in a case called Blue, where he talks about recollection. And we are all aware that, oh, I remember when I met you. It was a Monday. No, it wasn't. It was a Sunday. Oh, it was in London. No, it wasn't. It was in Edinburgh. So, my lady, my sole point on that is that gives the key to the correctness of the approach of the Court of Appeal, which is to interrogate the underlying material by reference to what the documentary evidence discloses, which is what the learned judge did not do. That's my sole point. And that in this case, given the lapse of time, each of these parties were in middle age trying to recall something that had happened a decade, not 3 decades, a generation before. And that's not a basis for suggesting that they had given dishonest evidence or had engaged in an act of fraud. And more than that, what the learned judge did not do, she didn't test the evidence by reference to the documentary evidence, didn't analyze it in the sequence that I suggested is the correct sequence, but she didn't test it by what was common ground between the parties. In other words, it was common ground between the parties that the Porters and the Stokes enjoyed a very warm and intimate relationship over a decade before the transaction took place. The evidence was that as a young couple, Mr. and Mrs. Porter, were old man Stokes, and I mean no disrespect, but I refer to him that way. In the record, you will see he was referred to by the Porters affectionately as Dada, as recorded by the Court of Appeal, so that there was a degree of warmth and intimacy. And therefore, there was no coherent nor logical basis for the court to have found that there was an act of deception or fraud or any act of dishonesty without wrestling with those facts and material. And they were amply supported by the detail in the record of appeal. And I will simply give you 2 instances. The first is that the Porters assisted the Stokes in their business. They had a magazine distribution business. It involved collecting magazines from the airport, which is not that far away in location, and helping them in their business. And that's on the business side. But on the more personal side, Mrs. Porter was a source of solace and comfort to Mrs. Stokes in the course of her illness prior to her premature passing. So not to have dealt with any of that, it doesn't appear anywhere in the judgment. Those 2 matters alone would provide an ample basis for the Court of Appeal, not only to interfere, as it were, consistent with the tests laid down by the board and Beacon and a variety of other cases I will not trouble you with, but also to carefully consider the totality of the evidence and come to their own findings.
Are you going to take us through the documents yourself?
I am.
Thank you.
I didn't propose to do that right now, my lord. I was going to, because I wouldn't get to the end of them, I was going to say something very quickly about the law. And if my lords and my lady permitted, I propose not to come back to it, if I may. Broadly speaking, although there is an attempt to suggest that the correct legal test for determining whether the claim for rectification was properly made out is that set out in the Court of Appeals decision, of which, of course, my Lady Rhodes is a part, in the FSHC case, I apologize. That case is clear and unequivocal authority for the proposition that where one is concerned with an anterior, that's how that case is presented, or prior concluded contract, that the objective approach is the correct approach. And to the extent that my learned friends in their written case have sought to criticize the Court of Appeal for anticipating what the English Court of Appeal decided as the correct approach, in reliance upon what Lord Hoffman said in Chartbook, we say that criticism is entirely misplaced. And
because there was a prior concluded contract.
Correct, my lord. As my lord well knows, because my recollection is that my lord sat at first instance.
I'm afraid,
in that case,
like Calais on the heart of Queen, when her post-mortem took place.
I have Chartbook. I can't say I'll have FSH
No, well, that's
on mine.
Fine.
Very good judgment.
So my lord, so we say the following. We say that the Court of Appeals, to the extent that there's a criticism that the Court of Appeal took the objective approach, they are in, with great respect, excellent company, if I may say so with respect. Not just my lord of first instance and the Court of Appeal. I believe in the minority was Lawrence Collins, Lord Justice, but also Lord Hoffman in the House of Lords, as far as a prior concluded contract is concerned. The majority of what the Court of Appeal was concerned to clarify the law about in the FS case was really to do with cases where there was no prior concluded binding contract. And so I can say in a sentence, that's not this case, and therefore that analysis, though interesting and fascinating because it kept journal writers busy for some time, does not need to detain this board.
I mean, I even wonder whether on Murray and Parker, which the trial judges cites at paragraph 53,
yes,
that isn't the true analysis, because there, Sir John Romilly says, sorry, I'm looking at page 295 now.
It's not correctly, my lord, it's not correctly transcribed by the judge. The better reference is 1140.
1140.
All right. Thank you. Let me just get that up just to see that I can make the same point. What I was seeking to draw attention to, and sorry, I'm not going to be able to do it very quickly, this.
Yes.
Oh no, it is here. It's page, so it's page 1140, internal page, as it's put in the English reports, 308, and it says, if there is a previous agreement in writing which is unambiguous, the deed will be reformed accordingly. If ambiguous, parole evidence may be used to explain, and in fact, looking higher up the page, again, the emphasis is upon, if there's a definite written agreement, all previous negotiation or propositions are extinguished, must be disregarded unless there be fraud. But then I think that's extended to common mistake. But one might say that what comes out of this authority is that if you have a definite binding contract, you look at the meaning of that contract, and the deed should follow the contract as objectively construed. Yes. But there may be ways to attack the contract itself if you can show common mistake.
Yes, my lord.
But just to pursue that, I wonder whether that is quite the way that the trial judge posed the issue for herself in this case, because at paragraph 56, she, if you like, she's referred to Marianne Parker.
Yes.
But then, if I may put it this way, she skips over the bit about if you've got an unambiguous binding written contract, rectifying the deed in light of that. And she moves between the real agreement or intention and a case of ambiguity, and then you go to parole evidence. So she's left out of account the case which ultimately I think you say the Court of Appeal decided was the true analysis, which is if there is a binding written contract here, it's an objective assessment unless and until someone can attack the binding nature of that written contract.
Indeed, my lord. And my lord, my lord's series of observations has anticipated my next single sentence submission, which is that the authorities, Murray and Parker, Fowler and Fowler, Crane, Chartbrook, and FS all support the respondent. All support the respondent. In other words, by virtue of their analysis, clearly and obviously and self-evidently, some of the outcomes are very different from what the Court of Appeal determined, but certainly in the majority of those cases, not only does the law support the respondents, but the factual outcomes support the respondent. And by that I mean simply the application of the law to the facts. And so that I say with the greatest respect that the Court of Appeal was in good company, both the older cases as well as those of more recent vintage, by a correct distillation of the principles and a correct application of the correct objective test in order to determine that the, what's the phrase, the convincing proof threshold was crossed and easily crossed. And in any event, I will be making a submission this afternoon, but I might as well foreshadow it now, that we respectfully say that my Lord Briggs's approach by way of his intervention with my learned friend, that there is an initial burden on the respondents, which they fully and adequately discharged, we say with great respect, beyond that of simply a prima facie case, which is how my Lord Bowers put it earlier this morning. But of course that the correct application of the appropriate standard of proof, which is unequivocally on the civil burden, notwithstanding there is an occasional lapse in some of the older cases into the language of burden of beyond reasonable doubt. We say that in any event, that analysis doesn't represent the modern law, and my Lord Briggs's approach is the correct one, i.e. that all that the respondents were required to do and did do in this case, as found by the Court of Appeal, was discharge that burden on the balance of probabilities as reflected the facts and circumstances of this case. And you've heard a lot about the documentary facts and circumstances, and with your leave, my lords and my lady, I'll come back to that this afternoon.
Yes. Well, that sounds like a convenient moment. Mr. Benjamin, thank you.